thank you everyone for attending this Radcliffe Chambers Junior Programme Seminar on Litigation. I'm Nick Macklam. I'll be talking about Estoppel by convention, and then Piers Digby will talk to you about costs on the small claims track. If you have any questions, please do put them in the Q&A box and we'll try and answer them when we've finished our talks. So I will kick off. Right, so the purpose of this talk is to introduce you to Estoppel by convention. So I'll cover its origins, its development in the English case law, the recent Supreme Court decision in the case of Tinkler against HMRC, which authoritatively sets out the relevant principles. And then I'll conclude with some observations on Estoppel by convention and what we might see in the future in relation to it. So first things first, estoppel is a familiar concept. We see proprietary estoppel and promissory estoppel cases all the time. And the general idea is that one party says or does something to another, which that other party relies upon, and the circumstances are such that the first party isn't allowed to go back on what he has said or done. And estoppel by convention is a similar concept. It's now considered to be an equitable doctrine, just as proprietary estoppel and promissory estoppel are. And it has its roots in two Australian cases. The first is called Thompson and Palmer. Now, that was a case where just over £1,000 was supposed to be paid in return for the transfer of some mortgages over properties. And the money wasn't paid because the conveyancing solicitor stole it. Now, in response to a claim seeking to enforce a vendor's lien over the property secured by the mortgages, it was ambitiously argued that the claimants were stopped from arguing that the money hadn't been paid. And it's in that context that we get the discussion of the principles of estoppel by convention that we can see on the slide. So we can see from the quote that the object of the doctrine is to prevent an unjust departure by one person from an assumption adopted by another as the basis of some act or omission, which, unless the assumption be adhered to, would operate to that other's detriment. So we can immediately see that, like proprietary and promissory estoppel, it's about stopping a party from changing position in some way. But its focus isn't really on stopping a party from resiling from representation. Rather, it's about stopping a party from resiling from an assumption. And then continuing the quote, we can see when the doctrine might operate. So it says whether a departure by a party from the assumption should be considered unjust and inadmissible depends on the part taken by him in occasioning its adoption by the other party. He may be required to abide by the assumption because it formed the conventional basis upon which the parties entered into contractual or other mutual relations. So in this quote, we've got four main ingredients for estoppel by convention. Ingredient one, an assumption shared between the parties. Ingredient two, the party said to be estopped has played a part in the adoption of that assumption. Ingredient three, the assumption has formed the conventional basis upon which the parties entered into subsequent mutual relations. And ingredient four, it's unjust to allow that assumption to be departed from because that would be to the detriment of the party raising the estoppel. So I said there were two Australian cases. That was the first one. The next is the case of Grunt and Great Boulder. And there's another quote on that slide. And we can see from that the reiteration of the ingredients that we just saw in the case of Thompson, with an emphasis on preventing injustice. So we can see from the quote the focus on an assumption of fact, which one party causes another to adopt for the purpose of their legal relations and an unjust departure from it. So those are the two Australian cases from the 1930s. And it's not really until the 1980s that we see estoppel by convention in its modern form really taking root in English law. And we see that in the case of Amalgamated Investment. So this is a Court of Appeal decision. And it was all about whether a guarantee given by a parent company to a bank covered certain debts in relation to a loan. Now, both the bank and the guarantor thought that the guarantee did cover the debts when they were carrying on business together. And so in reliance upon that, the bank allowed the loan to remain outstanding despite opportunities to call it in. And eventually, when the loan was not repaid and the bank came after the guarantor, which by that stage was insolvent, the guarantor's liquidator argued that the guarantee didn't cover the debts, so tough luck to the bank. So the bank sued the guarantor. It came on for trial before Mr. Justice Goff, as he then was. And there were really two issues. Number one, did the guarantee cover the debt? So a contractual question. And number two, even if the guarantee didn't cover the debt, was the guarantor estopped by convention from denying that the guarantee covered the debt? Now, at trial, the judge held that the guarantee did not cover the debt. So that was the answer to the contractual question. But the judge held that the guarantor was estopped from arguing that the guarantee didn't cover the debt, because those acting for the bank and those acting for the guarantor had, by their words and actions, repeatedly reinforced the mistaken belief of the other that the guarantee did cover the debt. And the judge decided that it was unjust in those circumstances for the guarantor to turn around very late in the day and say, oh, actually, we both made a mistake, the debt isn't covered. In circumstances where had the bank known the truth, it would have called in the debt earlier. So that got appealed to the Court of Appeal, and perhaps unsurprisingly, Lord Denning is a big fan of the estoppel argument. So he cites with approval the Australian judgments of Thompson and Grunt, and we can see his statement of the relevant principles on the slide. So he says, in this case, the parties, by their course of dealing, adopted a conventional basis for the governance of the relationship, of the relations between them, and are bound by it. When the parties to a transaction proceed on the basis of an underlying assumption, either of fact or law, and whether due to a misrepresentation or a mistake makes no difference, on which they've conducted the dealings between them, neither of them will be allowed to go back on that assumption when it would be unfair or unjust to allow him to do so. So there we have Lord Denning embracing the doctrine of estoppel by convention based on the Australian cases we've looked at. And on the next slide, I've included a quote from an early edition of Spencer Bauer, which was cited with approval by the other two judges in the Court of Appeal in the case of Amalgamated Investment. And it's quite interesting because it teases out the difference between estoppel by convention and other forms of estoppel. So we see it's founded not on a representation of fact made by a representor and believed by a representee, but on an agreed statement of facts, the truth of which has been assumed by convention of the parties as the basis of a transaction into which they're about to enter. And when the parties have acted in their transaction upon the agreed assumption that a given state of facts is to be accepted between them as true, then as regards that transaction, each will be estopped against the other from questioning the truth of the statement of facts so assumed. So broadly, if there's an assumed statement of facts between the parties, they then enter into a transaction on the basis of that assumed statement of facts, they can't then resolve from it subsequently. So amalgamated investment marks really the birth of the modern principles of estoppel by convention in English law. And then we get a series of cases in the 1980s and 1990s in which the doctrine starts to grow in all sorts of contexts, ranging from property law to shipping to commercial to civil litigation generally. And I've included some cases on the slide, and I'll run through them quickly just to give you a flavour of them. So the first, we've got Keane and Holland. That's a case where a landlord let a property to a tenant specifically on the basis that it would not have the protections afforded by the Agricultural Holdings Act. And the parties in the tenancy agreement attempted to exclude the operation of the Act, but that attempt was unsuccessful as a matter of law. And so a question arose as to whether the tenant was estopped from relying upon the Act in defence to a possession claim. Now, the estoppel argument didn't work in that case, and the Court of Appeal poured quite a lot of cold water on the argument, essentially on the basis that they said you can't achieve something by contract. If you can't achieve something by contract, then you can't get to the same place by an estoppel. So because the tenant couldn't contract out of the protections of the Act, the tenant couldn't be stopped from relying upon it. That's the first case. The next case on the slide is called the August Leonhardt. This is a case concerning a claim for damage to a cargo of sugar. The dispute was between the cargo owners on the one hand and the ship owner. Their respective representatives agreed an extension to the relevant limitation period on the basis and on the condition that a third party, the charterers of the ship in question, also agreed to an equivalent extension. Unfortunately, each party thought the other would ask the third party for the equivalent extension, and in the event neither did, and so the agreement was not effective and the limitation period expired. And so the question was whether the ship owner was stopped from arguing that the claim was time barred on the basis of the common mistaken assumption that an extension to the limitation period had been agreed. And on the facts, the Court of Appeal in that case held that no estoppel arose because although there was a mistaken common assumption, specifically that an extension had been agreed, the problem was that the ship owner wasn't responsible for the cargo owner's mistake because they each arrived at the same mistaken assumption independently. So there was no estoppel. And next, we've got a case called the Vistafjord. This is a commercial case involving a ship. It's about whether commission was payable to an agent on ticket sales in circumstances where there was a common mistaken assumption that commission would have been payable, and the parties had operated their relationship on that basis. And in that case, the Court of Appeal held that an estoppel had arisen. Now, on the next slide, we've got the case of Kenneth Allison. And this is, as I understand it, the first time that the modern principles of convention estoppel get a mention in the House of Lords. This was a case about whether a party was stopped by convention this is a case about the validity of service of a writ in circumstances where it had been served on the PA of a partner of a law firm rather than the partner himself, and the relevant procedural rules didn't allow service on an agent. Now, the House of Lords decided that the writ had been properly served by majority. And in his judgment, now Lord Gough of Amalgamated Investment fame concurred with that outcome, but he said he thought the conclusion should have been reached by reference to estoppel by convention, despite the fact that point hadn't actually been argued, because in that case, both parties had proceeded on the common but mistaken assumption that service on the agent would be effective, and the claimant had been influenced to adopt that mistaken assumption by the conduct of the defendant, and so it was unjust for the defendant to seek to resile from it at a late stage. So that's the sort of first mention of estoppel by convention in the House of Lords, but it's only Lord Gough, and it's in relation to a point that hadn't actually been argued in that case, so it was very much Overton. Next on the slide, we've got the case of the Indian Endurance, which is the first time the House of Lords really engaged in a bit more detail with estoppel by convention. It's a case where the argument failed on the facts. The context of the argument was whether the defendants were stopped from relying upon the Civil Jurisdiction and Judgments Act to argue that a set of English proceedings could not be brought because of earlier claims in India. So no estoppel on the facts of that case, but it's the first time the House of Lords engage with the principles in any detail. Then we've got the case of Johnson and Gorwood, which is a well-known case about abuse of process. One of the arguments raised in that case was whether a party was stopped from arguing that a claim was an abuse of process. In the event, the House of Lords decided that the claim wasn't an abuse, so the estoppel argument fell away, but it was dealt with in an obiter passage of Lord Bingham's judgment, with which two of the other judges agreed. So taking stock, we've got two Australian cases from the 1930s. We then get the Court of Appeal's judgment in Amalgamated Investment in the 1980s, which is really the birth of the modern principles in English law. And then we get its development in various cases in the 1980s and 1990s, including the Johnson and Gorwood case in 2002 as well, where those principles start to be applied and developed. So the next key step in the development of the doctrine is the case of HMRC against Bench Dollar Limited. This is a case from 2010, and it's where we find really that the first attempt by a judge to go through all of the previous authorities, extract the relevant principles from them, and summarize them in one place. So in Bench Dollar, HMRC had a problem. They had a dispute with lots of employers about national insurance contributions. HMRC said they were due and hadn't been paid, and the employers took the opposite position, said they weren't payable. And for reasons I don't need to go into, the procedural position was that the fight between HMRC and the employers about whether the contributions should be paid needed to be had in the tax tribunal, but in order to recover the contributions, they had to bring debt claims in the civil courts. And while the tax tribunal proceedings were ongoing, limitation was running in respect of the debt claims in the civil courts. So rather than issue lots and lots of claim forms protectively and have all the cases stayed, HMRC sought to extend the limitation period by getting the employers to acknowledge the debts. So they basically wrote to the employers and said, please sign and return this form acknowledging the debt, or we'll issue proceedings protectively. Unfortunately, the acknowledgements didn't work to extend the limitation period because the form said something like, we acknowledge your claim but dispute liability, which wasn't good enough to amount to an acknowledgement for limitation purposes. And so in the event, HMRC mistakenly allowed lots and lots of claims to become time barred in reliance upon these defective acknowledgement forms. And so the question was whether the employers were stopped by convention from arguing that the claims were time barred. And on this slide, we can see the summary given by Mr. Justice Briggs, as he then was, of the relevant principles drawn from the authorities. Now, I won't read all of them out, but we can see that there are 5 main ingredients. There's a common assumption that's shared between the parties. There's an assumption of responsibility by the party said to be estopped. We can see reliance in connection with subsequent mutual dealing. And we can see detriment and unconscionability if the party were permitted to resolve from the common assumption that they have some responsibility for. And in the event, in this case, the estoppel argument succeeded in respect of most of the employers. There was a common assumption, namely that limitation would be extended. The employers assumed some element of responsibility for that. They expected HMRC to rely upon their adoption of the common assumption. HMRC relied upon it in not issuing proceedings, and it would be unconscionable for the employers to resolve from it, given that HMRC didn't issue proceedings in reliance upon the common assumption, and therefore mistakenly allowed the primary limitation period to expire. So that's Bench Dollar in 2010, which is a really key case. Now, the next case on the slide is the case of Lindley Heath, which is a Court of Appeal judgment from 2017. And this was a case where there was a big fallout over the transfer of shares in a company, and there were various warring factions. And some shares were transferred in ignorance of preemption rights in a shareholders agreement. And later that shareholders agreement was discovered, and it was used in an attempt to unwind a transfer that had taken place in breach of the preemption rights in that agreement. And the High Court and the Court of Appeal upheld an argument that the party seeking to unwind the transfer was stopped by convention from relying on the preemption rights. Now, it's an unusual case because it's a case where the common assumption relates to something that had been forgotten. So that the common assumption was that there's no way of blocking this transfer of shares, and that common assumption arose essentially because everyone forgot about the preemption rights. But we can see from the quote from paragraph 79 of the judgment on the slide that the Court of Appeal says that's okay. It doesn't matter whether the true state of things has been misappreciated, misremembered, or forgotten. And in the second quote on the slide from paragraph 90, they reiterate the fact that the estopped party must have played a part in the adoption of the assumption. And in that case, the Court of Appeal decided that that ingredient was satisfied because essentially there was a very angry meeting at which the preemption rights should have been raised if they were going to be. What the Court of Appeal did do in that case is just tweak very slightly the bench dollar principles in the way that I've emphasized on the slide. But subject to that tweak, the Court of Appeal approved the bench dollar principles and held that they're a correct statement of the law. So that's Lindley Heath in 2017, and that takes us to the very recent case of Tinkler against HMRC, which was heard last year. It's a Supreme Court case, and unlike the House of Lords cases that we looked at a little earlier, where estoppel by convention got a mention here or there in obiter passages of judgments, this is a case solely about estoppel by convention. It's a tax case. It concerns a preliminary issue of whether HMRC had validly given notice of an inquiry into a tax return in 2005. The purpose of that notice of inquiry is to let someone, in this case Mr. Tinkler, know that HMRC are reviewing what has been included in a self-assessment tax return to check whether it's correct. So the idea is that they open an inquiry by sending a notice. They carry out the inquiry, and when it's finished, they close the inquiry and make a decision about whether the figures in the tax return are correct or not. And the problem HMRC faced in this case was that they sent the inquiry notice to Mr. Tinkler's former address inadvertently, which he no longer lived at, and it didn't reach him. But they did send a copy of the inquiry notice to his accountants who were acting for him. And the accountants wrote back to HMRC in response to the inquiry notice. And in their response, they expressly stated to HMRC that the tax return in question was the subject of an inquiry. And actually, they went a little bit further than that, because they said, because the return was under an inquiry, they couldn't do something they wanted to do. So they couldn't amend it to include something in it that they'd forgotten to include originally. And thereafter, from 2005 onwards, HMRC worked the inquiry, they asked questions, requested documents, checked whether what the return said was correct. And the accountants engaged with HMRC in relation to that. They checked things with their clients, got hold of documents and provided them to HMRC. So the deadline for HMRC to open the inquiry was in 2006, and that date passed, and HMRC didn't do anything about the fact that the inquiry notice had been sent to the wrong address, because they didn't know that. They didn't know anything was wrong, and they had been corresponding perfectly normally with the accountants. So they concluded their inquiry and made their decision about the return in 2012. And Mr. Tinkler disagreed with the outcome of the conclusion of the inquiry and appealed HMRC's decision to the tax tribunal. Now, the parties merrily went about preparing for that appeal until at a very late stage, Mr. Tinkler raised a dispute about whether an inquiry had been opened at all. And so the question of whether a valid notice of inquiry had been given was heard as a preliminary issue. And in the context of that preliminary issue, it was argued on behalf of HMRC that Mr. Tinkler was estopped by convention from denying that a valid inquiry had been opened. Now, the estoppel arguments got very different treatment in the various tribunals and courts. So the FTT decided that he was estopped by convention from denying the validity of the inquiry. I've set out the reasons for that on the slide there. The upper tribunal disagreed with that. They thought it was a case like Keane and Holland, that it wasn't possible for Estoppel to oust the formal requirements given by statute for giving a notice of inquiry. And the Court of Appeal agreed with the upper tribunal. The Court of Appeal held that Mr. Tinkler wasn't estopped. In their view, there wasn't any assumption of responsibility on the part of Mr. Tinkler acting by his accountants, and there was no unconscionability. Their view of the case was that this was a case where HMRC were totally to blame for what happened, and the accountants, BDO, were wholly blameless. So the Supreme Court reversed that, and it had a very different view of the situation. I've set out the key points on the slide. They are that the Supreme Court approved the bench dollar and Brindley Heath principles, thought it was largely irrelevant that HMRC were responsible for initiating the common mistaken assumption. And importantly, they held that by responding to HMRC as they did, and stating expressly that the tax return was under inquiry, the accountants endorsed or affirmed HMRC's mistaken assumption, and HMRC relied upon that to their detriment, such that it would be unconscionable for Mr. Tinkler to resign from it now, many years after the deadline to cure the problem had passed. And on this slide, we can see in a sentence or so, the Supreme Court's views on the case. Now, the title of this talk is Estoppel by Convention after Tinkler, and so I want to conclude by reflecting on how the doctrine may move forward in the future. And it seems to be moving into the mainstream, or at least more so than previously. In preparing for this talk, I did a search of cases which mention Tinkler, and it's cropped up in a lot of cases recently in a variety of contexts. And it's quite a flexible doctrine. It doesn't fit neatly into particular types of litigation. It can arise in all sorts of contexts. So it's worth knowing about. And I've included various cases on the slide. So the first one involved estoppel by convention being invoked in a contractual context, despite the presence of a no oral modification clause, which is quite interesting. And the second one involved it being raised in a property law context in relation to a breach of stakeholder contract claim. The third case involved the doctrine being raised in the context of an arbitration. And the fourth one, it involved it being raised in the commercial context. So it's a doctrine well worth thinking about in circumstances where parties have acted at odds to a particular contractual position or where a procedural defect is raised late. Because if the circumstances are right, it might be deployed to get your clients out of a tricky situation. So that's what I wanted to say about estoppel by convention. Thank you very much for listening, and I will now pass over to Piers.
Thanks for that, Nick. Excellent. So my talk today is going to be small claims costs, the exceptions explained. And this is just going to be running through some of the really small practical steps that you can do to try ensuring that your client's cost position is protected as much as possible, or that you're able to reclaim costs you might not otherwise get. The starting principle, obviously, with the small claims track is simply that parties will not be ordered to pay costs. And so that's CPR Rule 27.14.2. The court may not order a party to pay a sum to any other party in respect of that other party's costs, fees and expenses, including those related to appeal. So even if something gets bounced up quite far up the tree, you're still not going to be able to get costs back in respect of that. That can be quite limiting because something is a low value claim. That obviously doesn't mean that the litigation of that is necessarily going to be possible to always keep that cheap. It's simply expensive driving this process along, as I'm sure you all know. So today I'm going to be running through, firstly, the two major exceptions, one of which is mentioned in CPR Rule 27, but the boundaries of which are not always entirely clear, and that's costs when a party has acted unreasonably. And the other is the secret allowance, which is not explicitly referred to in CPR Rule 27, but it's well established, and that is the right to costs as enabled by contract. And in particular, I'm going to look at a specific example of that in the context of a service charge, where it often pops up. Finally, I will run through very briefly some of the smaller exceptions in CPR Rule 27 and what they might mean for how you think about litigating. So, unreasonableness. Starting point, CPR Rule 27.14.2g, such further costs as the court may assess by the summary procedure and order to be paid by a party who has behaved unreasonably. And the definition of unreasonably is not set out within the CPR itself in this context, but it is supported by CPR Rule 27.14.3, where a party's rejection of an offer of settlement will not of itself constitute unreasonable behaviour, but the court may take it into consideration when applying the test. So we're already getting a hint here that this often applies in the context of whether people are deciding to carry on or finish litigation, whether they accept an offer, whether they discontinue, whether they oppose particular sorts of application, and so on. So this has been looked at quite recently, in fact, in the Court of Appeal in 2017 in Bowman and Lanyon-Bogler LLP. And this was appealed twice, so starting with a deputy district judge and rising up from there to the Court of Appeal. And at the first appeal stage, the costs were given for two reasons predominantly considered. The first of those was that the skeleton argument and submissions were not considered to have a particularly good prospect of success. Now, this wasn't phrased specifically in those terms in the judgment, which led to some difficulty later on. The judge's precise words, but it was the very technical legal language that the claimant had been barking up the wrong tree. Which did cause some confusion in classifying things later on. The second reason that costs were given was that a generous offer, and one that, as a matter of fact, the judge considered to be reasonable under the circumstances, had been made to settle the claimant's case. And so for those grounds, costs were given. At the appeal stage, we see three main arguments coming forth from the appellant as to why the appellant's conduct had been reasonable, and so costs should not be made. And they were as follows. Firstly, the skeleton argument and submissions were clearly not unarguable as permission had been given to appeal. in the end, although the court, having sat down and given a fairly extensive examination of the point, decided that the claimant wasn't going to succeed. And certainly from the language of barking up the wrong tree, the claimant's position was probably never strong. It certainly was the case that this wasn't a complete no-hope. This wasn't something, for example, where the strikeout jurisdiction might have applied. It had been given permission to appeal. That permission had been given twice. There was a certain strength to the submissions, even if they were ultimately going to go on to fail. And for that reason, it shouldn't be considered unreasonable to pursue them. It is not unreasonable because you make a judgment call about something that has a margin of risk and go on to get that judgment call wrong. It has to be that you effectively don't make a judgment call, or your judgment call is so wildly wrong that it falls into unreasonableness. The second point was to say that even if it had no real prospects of success on the application of detailed analysis, that wasn't necessarily enough, as counsel for the appellant put it, to say that the continuation of the claim and the appeal was always unreasonable. And that was particularly important in this case because, and I haven't talked too much about the details of the base claim because it revolved around quite a complex principle of agency in relation to mortgages. And this was the point that the counsel for the appellant brought forward, which was that this was actually a very obscure point of law and one where the ramifications of that point of law were not going to be immediately obvious, even to, say, an experienced solicitor. And so because of that, even though at the first appeal, the judge was capable of saying, this just wasn't going to succeed once you applied these principles, counsel for the appellant said this is an obscure point. The difficulty of applying those principles means it's not unreasonable for someone to miss those or to have difficulty with them. And finally, counsel for the appellant said that while the offer was rejected, the appellant had made a counteroffer. They were still clearly open to negotiation. The fact that that offer alone was rejected, the court shouldn't have been able to consider it because there wasn't a final rejection. This wasn't the end of the process, a shutting of the door, and it was a continuation of the process of resolution. So conversely, for counsel for the respondent, we see three responses to that. Firstly, is to stress the fact that the appellant had been barking up the wrong tree, and although it wasn't unarguable, it was with the application of analysis a poor case at best. Secondly, while the point of law was obscure, in this particular case, it had been drawn to the appellant's attention by the defendant / respondent's own skeleton argument. This is something that had been made clear to them early on. The steps of law had been drawn out for them. And so the fact that perhaps it wouldn't be immediately obvious to someone approaching it from afresh was relevant. It wasn't being approached from afresh. This information had been provided to them. And finally, the previous judgment had made clear that the offer was very generous. Even if there was some kind of ongoing process, that rejection is still something the court could be taken into account. And so on these 3 points, the way that the Court of Appeal resolved it is to say as follows. Firstly, the appellant's submission just did have enough merit to receive permission of appeal, and it still had required some quite careful analysis of this fairly obscure point, even if it was ultimately wrong in doing so. And so on the facts of this case, the fact that the claimant / appellant probably had been barking up the wrong tree, that simply wasn't enough. It's not enough to be barking up the wrong tree. You have to be effectively in entirely the wrong forest. Secondly, although the opposing skeleton argument gave some assistance, this was a point of law that the Court of Appeal felt comfortable in saying was quite a contrived, it was quite an obscure one that gave rise to quite an intricate point. While it was true that once your attention was drawn to it and you did follow through all of the steps, then the claimant's case really did not stand up to very much. The difficulty in doing that was still something where it was sufficient for the Court of Appeal to say, this is not something we're necessarily going to expect people to grasp perfectly, and it's not unreasonable to persist in the face of that. Interesting that the wording of the judgment is such that perhaps if it had been clear that the appellant had realised this, or they'd shown some appreciation of it and fully engaged in that point, then that might have been a different result, because the importance here is that the obscurity stopped the party from being in a position to be able to make decisions as to reasonableness. They didn't have the clarity of understanding to be able to say this is something we can pursue, this is something we can't pursue. However, the appeal did fail on the final point, which was simply to say that although there might be some compensation ongoing, the fact that a reasonable offer was rejected was certainly within the terms of CPR 2714. So the court was right to consider it. But overall, although the court was entitled to consider it, by reason of the first 2 points being wrong and taking into account all of the facts of the case, the costs were not allowed because the claimant appellant's conduct was reasonable. While this case is very interesting because it allows us to see the thought process of an appellate court in approaching this, it's obviously not prescriptive, and as was pointed out in the judgment, we doubt if we can usefully give a general guidance in relation to the circumstances in which it will be appropriate for a court to decide whether a party has behaved unreasonably, since all such cases must be highly fact sensitive. So it's not the sort of judgment which is going to identify specific strands or modes of conduct where you can point at them and say, this is definitely unreasonable, we're entitled to our costs here. But it is useful for highlighting the features that are going to play into this, and in particular for borrowing this dictum from the wasted costs jurisdiction from Rydell and Horsfield, which is to say that conduct cannot be described as unreasonable simply because it leads in the event to an unsuccessful result or because other more cautious legal representatives would have acted differently. So the reason that we see issues like obscurity playing in is because they are clouding that ability to be able to make a decision about what should be done, or they prevent even a relatively cautious representative from being able to make these decisions. And you can see the wasted costs jurisdiction at CPR Rule 46.8, and there's obviously an amount of case law there which, by analogy, might have some relevance to helping determine reasonableness in the case of CPR 27.14. Although I would be careful about relying on it too heavily, because the wasted costs jurisdiction is not entirely analogous, as obviously that's often applying between parties and they're only for representatives rather than parties in relation to one another. So what are the two concrete points that the court did feel confident in saying? Well, they are as follows. Firstly, is that litigants in person should not be in a better position than legal representatives, but neither should they be in a worse position than such representatives. So this is to say that there's a limit to the obscurity argument. It's not sufficient for a litigant in person to say, look, it was very difficult for me to follow the law here. I'm a layperson, I don't have experience of this matter of law. Perhaps if I did understand the law, I would have known that my case was bad, I'd have dropped it. But the fact I didn't understand means that my conduct wasn't unreasonable. Please don't make costs against me. Well, the courts obviously had to draw a line here, and it's clear the advantages of the court doing so, because otherwise it's very much going to be in the advantage of litigants in person to play out their own lack of understanding, or to favour arguments which might draw things out, drive up the other side's costs, and are less good than other ones available to them, because then it's easier to ground that particular submission in the logic of, well, I was only making this because I didn't understand the underlying material. So litigants in person should not be protected any more than someone who would have been represented should have been, and this is something which I found can be quite useful to remind the court of. The second point, however, and this counterbalances is that obviously the reason that there are these costs restrictions on the small claims track is to encourage people to be able to use it. If costs were allowed, given that these are low value claims, the costs would often exceed the value of the claim, and then people would be put off from having justice resolved at all, because any gains that they might make could potentially be eaten up by the cost of the litigation. So because of that, there's a special and particular importance in making sure that judges think very carefully about reasonableness and don't rush in to make that kind of decision. And the Court of Appeal went on to say that this is especially true in respect of courts considering this at the appeal stage. So it would be very, very unusual where a costs order has not been made at first instance for an appeal court to be in a position to go back on that. And that obviously will inform the strategy of litigation. And finally and briefly on the reasonable offer, although it was proper for the court at first appeal to consider the rejection of a reasonable offer, that is something that they're entitled to consider. Just because a party rejects a reasonable offer, it doesn't follow that their conduct is in itself unreasonable. There's a wide range of reasonableness in offers. Simply because one offer is reasonable, it doesn't mean that there are no other reasonable offers. In fact, there's a wide range of offers in which the parties might consider settling when weighing up the balance of costs. Although it's not explicitly drawn out in the judgment, that the natural inference is for it to be a strong decider, you would have to see someone rejecting something that is really at the very upper bound of reasonable offers, so that by rejecting it, you are effectively leaving no other room in which any other reasonable offer can operate, because you've already cut out the one that was at the top of the range of options. And so, in summary, to draw from those points, if you're looking to show unreasonable conduct, what you're wanting to see are a plain and obviously bad point, and one it's not obscure, it's an easy area of law to spot, it's something that the claimants defendant simply shouldn't be bringing, preferably in an area of law that's well known and would be easy for a legal representative of the ordinary skill and experience to be expected to spot and identify, and the rejection of a reasonable offer which is at the top bound of reasonableness. And these are the sorts of situations in which you might be able to find that actually you can get costs back as a result where the costs have been brought about by this unreasonable conduct. These are obviously the edge cases, which is why I highlight them. There's also the much more obvious ones where it's going to be on the table from the start, which is vexatious conduct, litigation designed to harass, causing serious delay in the conduct of proceedings. But they're almost less interesting in that they're sort of obvious to spot, and you're going to know that you're probably going to be able to get costs back in those situations. So the second one, and this one is a bit sort of sneakier, which is why I've highlighted it as the secret cost, because unlike reasonableness, it's not highlighted in the CPR, and that is contracts for costs. And so somewhat recent, you have Chapler Limited and Kamari. And this was in respect of a service charge claim, and I'll come back to touch upon that later, because they're a frequent form in which these contractual provisions appear. So the Court of Appeal saw that the parties had contracted such that the successful party, although the claim had been brought in the small claims track, should be entitled to its costs. Obviously, the unsuccessful party tried to get out of that by saying, well, small claims track, nothing they can be given here. And the Court of Appeal considered that Chapler had been entirely right to point to the contractual provision for costs. Now, why is this the case when this is not highlighted in CPR 27? It seems very odd to have this rule when the plain language of CPR 27 is very clear, and that's that the court may not order costs. And the reason for that is because here the costs are not directly payable under the provisions of the CPR per se. It's not the court ordering costs on the basis of the court's own innate ability to do so. It's because it's under the terms of the contract, in this case a lease. It is enforcing a term that the parties have between themselves, and simply collapsing the stages, in the sense that it would be a real nuisance if you had a contract for costs after the conclusion of your case. You then had to send the bill for costs over to the other party, they didn't pay up, and then you had to start a new claim for breach of contract. It's simply collapsing those stages into one stage. And so it's not caught by CPR 27 because it's not, strictly speaking, a CPR matter, according to the reasoning in Chapler. This is in itself was drawing on Church Commissioners Ibrahim, and you can see here the relevant passage, which is effectively summarising that principle. That this is a contractual right, and one that the court should be very wary of interfering with. Now, this isn't to say that the court can't interfere with it, and this is something to be a little aware of when bringing claims on this basis, because the court's power to decide by whom costs should be paid, for example, probably couldn't be fettered by a contract between the parties, as pointed out in Church Commissioners, to the extent that for example, successful litigant should have to pay costs to an unsuccessful litigant. So if you had a contractual clause that said, even if we lose, you pay our expenses, the court's probably not going to allow that because of the public interest in not allowing people to run roughshod over the normal principles of costs. So the court can escape from this, and there's further provisions for that in the CPR. So we can see here CPR Rule 44.5 that allows for the presumptions in paragraph 1, and paragraph 1 obviously mimics the terms in Commissioners and Ibrahim. It allows them to be rebuttable, so they can be moved around, but it's going to be difficult to do that. And the general presumption is very much that if you have a contract for it, you're going to get your costs on it. A specific example where this pops up a lot, Section 146 proceedings and how they relate to service charges. So you will often see in leases a covenant to the effect that the lessee will pay the expenses, costs, charges, etc., incurred by a landlord in or in contemplation of proceedings or notice under Section 146 of the Law of Property Act 1925, or some variation there too. Initially, this might seem quite circumscribed, because Section 146 of the Law of Property Act 1925 simply prevents a landlord from exercising a right of re-entry or forfeiture under a lease until a notice has been served and the lessee has been given the opportunity to remedy the breaches complained of. So it might, you might be thinking, well, this doesn't seem that useful a clause. I mean, how often do things get all the way to the stage of re-entry or forfeiture? That's the a wide range of claims we want to bring that this clause doesn't seem to cover. But it is actually significantly wider than it looks at first glance. And so we see that this in freeholders of 69 Marina and Orham, a 2011 case, which saw the reasoning being given for why I've just seen the anonymous attendee's question. I will get around to that very shortly. Apologies. Yes, sorry. We was looking at why this actually extends to claims that given respective service charge. So the reasoning for that is that under Section 81 of the Housing Act 1996, a landlord can't exercise a right of re-entry or forfeiture for failure by a tenant to pay a service charge until a leasehold valuation tribunal has determined it's so payable. So a precondition of being able to exercise your Section 146 right is having undertaken your Section 81 conditions, that you've gone away and you've got this determination, and that's reinforced by Section 168 of the Common Hold and Leasehold Reform Act. So if you want to get to the stage of that Section 146 notice, if you're contemplating that, and bearing in mind the usual wording is in contemplation, then you have to have done the prior stage of gone away and getting a determination by the Leasehold Valuation Tribunal. And so, as was considered in freeholders of 69 Marina, this brought these sorts of claims into the remit of those cost clauses and allowed the lessor in these cases to be able to get back their costs. And this is significant on two grounds, in that firstly, this was applied even though no Section 146 notice had actually been served, and so you didn't have to get the determination, serve the notice, and then come back for costs. It collapsed again into a single stage where you're just able to go get those costs. And secondly, nor is there even a need to plead a Section 146 notice will be served at some particular future point, or is actively under your contemplation now, for the simple reason that depending on how the determination of service charges goes, obviously the need for a Section 146 notice might be obviated. There might be some sort of settlement that renders it unnecessary. It's the sheer fact that if you were to do one, then it would be a necessary precondition, and that brings it into the contemplation. Finally, and very briefly, a few special cases. So firstly, possession hearings. These will only end up on the small claims track if the parties agree, per CPR rule 55.9. Simply because the parties have agreed they're allocated the small claims track, that doesn't mean that they become ruled by the small claims track costs. They actually remain effectively under the fast track costs jurisdiction, unless an additional and further agreement is made under CPR rule 55.94 that when the parties agree the court will allocate the claim to the small claims track, the court should also apply the small claims track costs. And so don't forget that stages 2 and 4 are separate agreements there. Simply because you've agreed on 2, that doesn't necessarily mean 4 will follow, and you still have to be aware of your cost exposure. The small claims track rule extent means it is not always just the small claims track either that these restrictions are applying to. So once a claim is allocated to a particular track, those rules will apply to the period before as well as after allocation, except where a court of practice direction provides otherwise. And that means it can be a good idea to think about the timing of certain applications. Do you want to make sure that they have definitely been made after allocation to a particular track, or are you confident enough that this is something that will go onto the small track, and so you can make it now in the knowledge that it will be governed that way regardless. So you might want to have a certain level of confidence in allocation before you bring certain levels of application. And finally, settlements. If there is a settlement of a claim before it is allocated, where it obviously would have been suitable to the small claims track, then the court can apply the small claims costs jurisdiction backwards. So for those reasons, that's a good reason to bear in mind unreasonable conduct and contractual provisions for costs, even if something hasn't necessarily yet been allocated. Just to turn to that question very briefly and to conclude, I'm asked, in respect of unreasonableness, what is your view on a scenario where the claimant, a litigant in person, is unreasonable in their behaviour rather than their legal case or response to settlement, such as sending an unprecedented volume of correspondence and deliberately increasing the amount of legal fees to the respondent, being aggressive in correspondence and contacting numerous individuals rather than just the solicitor on record. I think that's very clearly the situation where, similar to the waste costs jurisdiction and looking at the case law and Rightal, this is something that just very clearly falls into unreasonable conduct, and I think the court will find that relatively straightforwardly. What I've been predominantly looking at in this talk is sort of the areas where it's less clear, and the most difficult grey area really isn't about when a claimant has been unreasonable in deciding whether to continue a claim or end it early or settle, etc. But yes, thank you for attending.